Welcome again, everyone, to another edition of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am Rich Lenkov. I'm the CEO and founder of SERMA, and I'm also the host of the SERMAPod. And we are discussing today a groundbreaking decision as part of the House versus NCAA class action lawsuit. We're very privileged to have one of the experts on this issue, Professor of Law and Executive Director of the National Sports Law Institute at Marquette University Law School, Matt Mitten. Professor, thanks for joining us on the podcast.
My pleasure, Rich.
So this agreement came in May. We're about a month in, and this still must be approved by a federal court judge overseeing the case. Why is this case so significant? Why is this settlement so significant?
Well, this would be the first time where universities, specifically NCAA Division I universities, would be able to engage in revenue sharing with their student athletes, intercollegiate athletes.
And this is between the NCAA and the Power 5 conference. Could you explain for those of our listeners and viewers who don't know what that means, what that is?
Yeah, the NCAA is a membership association of about 1,100 public and private universities, also consists of 100 athletic conferences. And the schools are divided up into three different divisions, 1, 2, and 3. And then within Division 1, you've got three separate subdivisions. There'd be Division 1 FBS football. That's about 135 schools. Then Division 1 FCS schools. I think there's about 100 of those. That's football championship series. And then there's a total of about 350 Division 1 schools. And then the third category would be those who don't have intercollegiate football teams, like Marquette. So the House lawsuit was the NCAA that was sued as an association, as well as at the time there were 5 autonomy conferences within Division I FBS. That was the Big Ten, ACC, SEC, Big 12. The Pac-12 still exists, but it's only 2 schools, so it's really the autonomy or Power 4. That's what the antitrust suit was brought against by a group of Division I intercollegiate athletes. I think it was largely football, men's and women's basketball players. So that's, the settlement will basically resolve that case as well as 2 others that were consolidated with it and are pending before Judge Wilkin in San Francisco Bay Area. She was the trial court judge in both the O'Bannon and the Alston case, which made it up to the U.S. Supreme Court.
So, Professor, is it only athletes in the sports that you mentioned that are affected, or are other athletes on campus also going to benefit from this?
No, it would be others, because there's 2 main components of the proposed settlement. There would be a fund of about $2.8 billion that would get distributed out as past damages. The claim is basically that it wasn't until July 1st, 2021, that college athletes could begin earning NIL rights income. So when this suit was filed, I think back in 1920, once there was some announcement by the association that they would permit college athletes for the first time to earn NIL rights income. So there's a 4-year statute of limitations. So it would go all the way back then. And that, rather large pot of money, they're going to have to come up with some framework of how that will get distributed to really all college athletes or NCAA athletes within that. It's interesting. The case was brought by largely only the athletes who play the revenue generating sports, which is for the most part Division I football, men's and women's basketball, I should say FBS football. But I believe that all intercollegiate athletes will get potentially at least some share of that large slice of pie. And then going forward, Division One, the 350 Division One universities, they can on an annual basis share revenues up to, I think it's going to be between 20 to 22 $1 million.
So, of course, that is good news and bad news in some respects. Bad news for some smaller institutions or ones that are less competitive in sports, right, who don't have that kind of revenue to share with their student athletes going forward. How might that further create a division between the have and have-nots when it comes to college athletics?
Yeah, let's take a look at basketball, Division One basketball. I use Marquette as an example. So Marquette plays every year against University of Wisconsin in Madison. Madison or Wisconsin is getting its pro rata share of the Big Ten's multi-billion-dollar deals to televise all their sports. So they're going to, no doubt, University of Wisconsin generates more annual revenues from their athletic department than Marquette. We don't have a college or intercollegiate football team, just the basketball program. So, yeah, there's very much going to be a division there. And also it'll create a further division within Division One FBS football between what's now the Power Four conferences and the others like the Mid-American Conference, Mountain West, American Association Conference, all of those. So, no question. Because currently today, the SEC and the Big Ten have the biggest media contracts, far larger than what the ACC and Big 12 schools have.
So, Professor, I know there's a lot of details yet to be worked out. But, for example, do we have any clue as to how much each athlete would make? And is there a sliding scale? Do underclassmen earn more or less than upperclassmen? Does it depend on how highly you're recruited? Do stars get more money than lesser known players? Does it depend on, jersey sales or NIL deals? I mean, there's all sorts of ways to compensate. I wonder how that's going to be done.
Well, that's the $64,000 question. Actually, it's probably more of a $64 million question. There aren't any details on that. One of the things, because at least at this point, they haven't said it's just up to each school. Here's this large, $20 to $22 million pot of money. First thing they're going to have to do is you can't just give it all to the male athletes because you've got Title IX gender equity. So they're going to have to figure that out. And then the question is going to be, okay, how much do we allocate per team? And then, it doesn't look like there's going to be any restrictions on, assuming you comply with Title IX gender equity, how a school would choose to pay out the money. You would expect the athletes who are, more sought after in the revenue generating sports like football and men's basketball, women's basketball probably too, are going to get, more. But that all, I'm not sure the settlement's even going to address that. They might just say, hey, it's up to each school as to what they want to do.
Professor, is this in essence the end of amateurism as we know it in college athletics? Some find that to be a disturbing trend. Others think it's about time that college athletics jumps into the 21st century where there's billions of dollars swirling around and the principal generators of that revenue, the players, have until now not been compensated. Is it either of those, neither? What do you think?
Well, I think it's, so college athletics started out under an amateur educational model. And then clearly with football and basketball shifted to a commercial academic model. And I think arguably as of July 1st, 2021, across the board, it's been a commercial academic model because college athletes for all the sports, not just the revenue generating ones, could earn NIL rights income, but that came from third parties, not the school. So this will be the first time that schools themselves can directly pay athletes. So yes, I think amateurism is, at least as it used to be known, playing just solely for the love of the game, no economic benefit. Although, of course, athletic scholarships very valuable for those fortunate enough to get those. So yes, this shifts over to the commercial model. I don't know that we're fully professionalized yet, because what remains to be seen is, well, can college athletes unionize like professional team sports athletes can do? Are college athletes covered by the Fair Labor Standards Act? There's some litigation out there on that. Question would be, well, if a college athlete gets hurt, are they an employee who could cover or be covered by and get workers' comp benefits under state law? So we're in a very uncertain time, to say the least.
You mentioned collective bargaining. Of course, that has been a cornerstone of professional athletics and the rise of compensation over the years in professional sports. College athletes, except for one exception at Dartmouth, aren't unionized. That is probably the reason why in this agreement, I think there's a 22% split versus most professional leagues where players get more like 50%. Do you see that evolving over time so that college athletes are getting a higher percentage similar to the professional athletes than this 22%?
I think it's pretty unlikely, because one of the big differences between professional and college sports is professional sports, these are for-profit entities, and pretty much all of the teams generate more revenues than expenses over time. And you've got, largely the biggest source of revenue is from, the media contracts. Like the NFL has the most revenue sharing, and pretty likely that every single NFL team is earning a profit every year. It's different. There's typically only about 20 or 25 NCAA university athletic departments that generate net revenues. And those are largely, it's almost always roughly the same Division I FBS schools who are in one of the four autonomy or power conferences. So it's a very different economic model. And the only sports that typically generate revenues that pay for themselves are men's football and basketball. So I don't think, even if college athletes were permitted to unionize and collectively bargain that percentage, it would be anywhere near the roughly 50-50 split that we see among the four major professional men's leagues, major leagues in the U.S.
Professor, last question we have for you here on the SERMAPod. While this settlement represents a groundbreaking legal development and certainly doesn't portend the end of litigation in this area, what do you think we will see in terms of litigation going forward after this? I mean, there's a whole host of issues I think that will be litigated, but can you give us your thoughts on perhaps a couple of them?
Yeah, it's interesting. This is not going to get rid of all the antitrust litigation, because there's a case rather similar to House that is pending in federal district court in Colorado. And there, the judge refused to transfer the case out to California so there could be the global settlement here. And counsel representing the student athletes in that case have already said, no, we have no, just because even if there's a settlement of the House and the other two cases in California, this case is going forward. So, and then you're going to have some athletes, even who are part of the class, in one of the three cases in California, they might decide to opt out, say, no, we don't think that this is appropriate. We're not happy with the settlement. And it's going to be very interesting to see what Judge Wilkin does in California, whether she determines that this settlement is fair and reasonable on the part of all the parties, because there are certainly some athletes and their agents now who aren't happy with it. Certainly some NCAA member schools that aren't happy with it. And I suspect once there starts to be some payouts, you're going to probably see some Title IX litigation against individual schools or conferences saying, wait a minute, the women athletes aren't getting a fair share of this. So there's probably going to be more rather than less legal issues, although at least some of the antitrust issues can be resolved, and you might take some of the major plaintiffs' antitrust lawyers like Jeff Kessler and Steve Berman. They've already said, well, we're not going to be continuing to bring these same types of antitrust cases. But there's others out there. And, when you've got roughly 500,000 plus intercollegiate athletes, there's always someone who can find some rule or group of rules that they don't like and claim my economic interests are hurt, so I'm going to file an antitrust suit.
Well, our listeners and viewers will have to continue to follow our podcast and updates for this continuing legal trend. Marquette University Law School professor Matt Mitten, also executive director of that school's excellent National Sports Law Institute. If you want to study and go into sports law, that is the premier program of its kind in the country. I was fortunate enough to attend the recent gathering up in Milwaukee, and it was just incredible. Professor, thanks so much for joining us on the SERMAPod today.
Really enjoyed it, Rich.